October 1st, verbal abuse. Threatened to rain down legal and financial hardship. Threatened to report me to Chris Healy from NDOW, Nevada Department of Wildlife. Viciously and vehemently refused to remove her name from parents' joint U.S. bank account, recommended by attorney Steve Moss, while in his office. She writes a personal check to herself for $1,750, causes account to be overdrawn. October 3rd and 4th, I closed the joint account and opened a new account at U.S. Bank. October 17th, text message. My wife and I received this text message at 11:30 p.m. Quote, I hope Roger has his disability in order. Also, maybe he'll sell your parents' house for his disability fraud since he has power of attorney. That will give him some money. November 30th, threatened over phone to deny me access to residence at 2685 Nob Hill Drive. She illegally enters residence and room and removes various personal property, medical records, legal documents, journals, files, miscellaneous mail, etc. Admitted this to Washoe County Sheriff's Office, WCSO. Unauthorized reopening of parents' U.S. Bank joint account. Removes $3,700, causing account to be overdrawn. Later apologizes for the wrongdoing. My wife and I called Washoe County Sheriff's Office, WCSO, non-emergency, and asked how to obtain a temporary protective order. December 2nd, she places a 911 call to WCSO, Washoe County Sheriff's Office, and falsely reports to dispatch that, quote, my brother is stealing all the personal property from residence 2685 Nob Hill. December 4th, she removes 2 diamond rings from residence, photos, picture frames, and various other items. December 19th, verbal abuse and threatening me to produce keys to home and autos while at Christmas dinner for father at Lakeside Manor Care. I did not engage. She aggressively followed, blocked my way to elevator, and continued to threaten more financial hardship by attorney tod.torvinen. 9 p.m. Wife and I stopped by WCSO, Washoe County Sheriff's Office, to talk about threats and harassment while at Christmas dinner at Lakeside Manor. It was recommended by Washoe County Sheriff's Office to file temporary protective order, TPO. December 20th, she calls 911 emergency dispatch to Washoe County Sheriff's Office. Quote, my brother is illegally residing at 2685 Nob Hill and will not vacate premises. She was out of control, abusive, screaming, get the fuck out of here and take your dogs with you, or I will have all of you permanently removed. After Washoe County Sheriff's Office Deputy Vanderwall and Koos and others leave, she continued to invade my privacy, trespass in the room of my wife and I by rifling through drawers, looking for keys to the home and cars. December 23rd, she attempted to gain access to 2685 by jimmying door locks, checking windows, told me previously she would gain access with the help of a locksmith. I'm fearful if she gains access to the residence, I have firearms and money in the home. Inappropriate use of parents' U.S. bank account funds to retain attorney. Inappropriately enters a legal real estate contract with father. I have been granted through the Hillygus Family Trust power of attorney for health care and financial decisions for both of my parents. I'm concerned for everyone's safety and must continue to care for both of my parents into the future. 6.1.1. The trustee may sell all real property owned by the trust at the time of the death of the surviving settlor and divide the net sales proceeds equally between Roger E. Hillygus and Robin R. Hillygus Renwick, and distribute the proceeds outright and free of trust. Roger E. Hillygus and Robin R. Hillygus Renwick may elect to retain all or some of the real property. In that event, such real property will be distributed to them as tenants in common, each owning an equal undivided 1/2 interest. Roger E. Hillygus or Robin R. Hillygus Renwick may elect to receive his/her share as one more of the real properties. Regardless of the manner in which the real property is distributed to Roger E. Hillygus and Robin R. Hillygus Renwick, in cash or property, the value of the distribution to each of them must be equal. Should either Roger E. Hillygus or Robin R. Hillygus Renwick dispute the retention of real property by the other, then all real property must be sold and the proceeds divided equally between them and distributed outright and free of trust. If either H.U.G. Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of the surviving settlor, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renwick shall serve as successor trustee. In witness whereof the settlers set their hand and seal, and the trustees have caused these presents to be executed on the day and year first above written. Settlers H. Eugene Hillygus, Susan L. Hillygus. Trustees H. Eugene Hillygus, Susan L. Hillygus. State of Nevada, County of Washoe. On this 24th day of August, 2011, H. Eugene Hillygus and Susan L. Hillygus, as settlers and trustees, known or proved to me to be the same persons whose names are subscribed to the foregoing instrument, personally appeared before me and acknowledged that they executed the foregoing instrument freely and voluntarily for the uses and purposes herein expressed. Stephen.C.Moss, Notary Public. All terms of Hillygus Family Trust, restated, dated August 17th, 1993, shall remain the same, except for the following. 1. The existing terms of section 9.1.2 are deleted in their entirety and replaced with the following. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of both settlers, or the surviving settlor, Adam Clark is appointed as successor trustee. Dated this 11th day of June, 2014. Take note of the date here, specifically the year. It says dated this 11th day of June, 2014. From the Law Office of Tod.Torvinen, chartered, Tod.Torvinen, Esquire, attorney for Robin.Renwick. Certificate of Service. Pursuant to NRCP, Nevada Rules of Civil Procedure 5B, I certify that I am an employee of the law office of Tod.Torvinen, and that on June 11, 2013, I served a copy of the foregoing document on the parties identified below by using the ECF system, which will send a notice of electronic filing to the following: Steve Moss, Esquire, Michael Springer, Esquire. Take note of the date here on the certificate of service, specifically the year. It says June 11th, 2013. Typo?
(2630) Don L. Ross, Nevada bar number 3802. Jason Morris, Nevada bar number 10689. Lauren D. Burkich, Nevada bar number 12357. Woodburn and Wedge, 6100 Neal Road, Suite 500, Post Office Box 2311, Reno, Nevada 89505. Attorneys for Roger Hillygus. In the Second Judicial District Court of the State of Nevada in and for Washoe County, in the matter of the Hillygus Family Trust, dated August 17, 1993. Case number PR 14-00025. Department number PR, which stands for probate. Hearing date June 19, 2014. Hearing time 8:15 a.m.
Objection to petition regarding administration of revocable trust. Roger E. Hillygus, by and through his attorneys Don L. Ross and Lauren D. Burkich of the law firm Woodburn and Wedge, hereby submits his objection to petition regarding administration of revocable trust filed by Stephen Moss, purportedly on behalf of H. Eugene Hillygus. This objection is based upon the following Memorandum of Points and Authorities.
Memorandum of Points and Authorities. H. Eugene Hillygus, hereafter Gene, and Susan L. Hillygus, hereafter Sue, executed the trust agreement for the Hillygus Family Trust on August 17, 1993, attached hereto as Exhibit 1. Section 9.1.2 of the trust agreement provides as follows. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor and trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renwick shall serve as successor trustee. Although the language of this section is poorly drafted, Section 9.1.2 manifests Gene's and Sue's clear intent that in the event neither of them is able to act as trustee of the trust, then their son, Roger H. Hillygus, hereafter Roger, is to serve as successor trustee of the trust.
Gene's and Sue's intent in this regard was verbally confirmed by them in a meeting held with their children and Mr. Moss while in Mr. Moss's office on October 2nd, 2013. The various players in this unfortunate family drama and their counsel are all aware that Gene suffers from dementia and that Sue suffers from the effects of Alzheimer's disease. That situation was, in part, the reason for the Hillygus family to meet with Mr. Moss in October of 2013. On December 11th, 2013, Mr. Moss drafted a letter to Dr. Kent Elliott, M.D., of the Renown Medical Group. In his letter, Mr. Moss states, in pertinent part as follows. Emphasis added. As Gene's physician, I respectfully request, on behalf of the trust, a written certification that addresses whether he is incapacitated, as defined above, and able to properly handle his affairs, i.e., manage the trust. This certification will also determine whether Gene is able to make appropriate decisions about his health care. Gene signed a health care power of attorney that designates Roger E. Hillygus as his attorney-in-fact for health care decisions in the event Gene and his wife Susan are incapacitated. A copy of the signed power of attorney for health care decisions is enclosed with this letter. I believe that Gene and Susan are incapacitated and unable to make healthcare decisions for Gene. Therefore, Roger E. Hillygus is authorized to make healthcare decisions for Gene. In response to Mr. Moss's request, Dr. Elliott evaluated Gene on December 13, 2013. In a letter to Mr. Moss of that same date, Dr. Elliott stated as follows: "It is my medical opinion that Herbert Hillygus suffers from an irreversible and progressive vascular dementia. As a result, he does not have the capacity to properly make his own healthcare decisions, nor is he able to properly handle his financial and legal affairs, including handling his family trust." Inexplicably, within about 2 weeks following Mr. Moss's receipt of Dr. Elliott's letter, Mr. Moss prepared an amendment to the trust agreement to be signed by Gene, despite Dr. Elliott's determination of Gene's incapacity. With Mr. Moss's assistance, Gene signed the amendment on January 3, 2014. That amendment is now the subject of the instant petition in which Mr. Moss, purportedly on Gene's behalf, seeks to enforce the terms of the amendment.
Prior to the previously scheduled hearing on the petition, Mr. Moss and Gordon Muir, Esquire, who is counsel for Sue, met with the undersigned counsel for Roger. Among other things, it was agreed that both Sue and Gene would be further evaluated by a neurologist. Gene had previously refused to keep 2 appointments with Dr. Jonathan Spivak, a neurologist who was to further evaluate Gene. So the agreement among counsel was to be sure that each of Gene and Sue would be evaluated within a certain time frame and that the original hearing in this matter would be vacated.
Gene was finally evaluated 3 times during the month of April 2014 by Dr. Deborah Fredericks, a psychologist. Gene was accompanied at each of those visits by his daughter, Robin. Dr. Fredericks determined that Gene, quote, has a vascular dementia and is not, quote, competent to make decisions about managing his personal financial affairs, including changing successor trustees and amending distribution of his estate. So, in light of a determination of incapacity immediately prior to Gene's execution of the amendment, and a determination of incapacity shortly after Gene's execution of the amendment, one has to ask, how is it that Mr. Moss can claim that Gene had sufficient capacity to execute the amendment? We also need to ask why we are exhausting this family's very limited resources to litigate this issue. It simply makes no sense.
Sue was out of town and was not consulted regarding the amendment to Gene's and Sue's joint trust, nor was Roger Hillygus ever consulted. Roger is the person who is appointed to act as Sue's attorney in fact pursuant to a validly executed power of attorney, prepared by Mr. Moss. Article 4 of the trustee agreement provides in pertinent part as follows. 4. Write, amend, or revoke. The settlers may, by a written instrument, signed, acknowledged, and delivered to the trustees during the settler's life, revoke this agreement in whole or in part, and amend it from time to time in any respect. This language requires that an amendment be signed by both settlers. Nowhere in the trust agreement does it say that during the settlers' joint lifetimes, one settler can amend the trust agreement. This is standardly the case. It is a joint trust, and all amendments must be made jointly while both spouses are alive. After Gene moved out of the marital residence, Roger and his wife, Debbie, moved in so that they could care for Sue. Sue prefers to live in her home, and it has been suggested that maintaining her routine and having stability is beneficial to her. Roger and Debbie selflessly left their home in Dayton to move to Reno to assist Sue. Roger had been commuting from Dayton, Nevada on a regular basis for several months to provide care and assistance to his parents. Rather than be thankful for this family support of Sue, Robin and Jean began a campaign against Roger and Debbie, which eventually resulted in Roger and Debbie being evicted from the marital residence. Sue was then left alone in the home by Jean and Robin and ultimately had a breakdown and ended up in the hospital after Roger found her lying on the floor of the residence. Throughout this period, Mr. Moss repeatedly advocated Jean's position that Roger could not live in the home to care for Sue, that Sue should leave the marital residence, and that the home should be sold. Therefore, notwithstanding Mr. Moss's original representation of both Jean and Sue, since mid-December 2013, Mr. Moss has undertaken to represent Jean alone without regard to Sue's interests or desires. Because of his prior representation of both Jean and Sue, Mr. Moss had an ethical duty to withdraw from representing either of them at the moment Sue's and Jean's interests diverged. Mr. Moss has never obtained, or to the best of Roger's information and belief, ever attempted to obtain a signed waiver from Sue or her counsel, which would permit him to continue to represent Jean in matters that are adverse to Sue's interests. Mr. Moss was reminded of his duty to withdraw by the undersigned in mid-January 2014, and again in February of 2014. Once both Jean and Sue had been deemed incompetent by two doctors, Roger assumed his duties as trustee. See Notice Confirming Appointment of Successor Trustee, attached hereto as Exhibit 2. Jean and Roger's relationship improved over the last few months, and Jean has decided that Roger should be confirmed as the successor trustee. However, Mr. Moss, without his client's authority, still persists in his frivolous attempts to confirm the amendment, with the result that the Hillygus family's limited resources continue to be needlessly squandered on legal fees. Roger respectfully requests that this court deny the petition. Roger and his wife, Debbie, have tirelessly cared for Sue. Roger is committed to responsibly serving as successor trustee of the trust. The undersigned affirms that this document contains no social security numbers, dated this 18th day of June, 2014, by Don Ross, Esquire, signed by Lauren D. Burkich, Esquire, attorneys for Roger Hillygus, successor trustee. Affidavit of Roger Hillygus, State of Nevada, County of Washoe. I, Roger Hillygus, being first duly sworn, depose and state as follows. 1. I am the trustee in the above captioned action and make this affidavit of my own personal knowledge. 2. I have read the accompanying objection to petition regarding administration of revocable trust and know the contents thereof, that the same is true of my own knowledge, except as to those matters which are therein stated on information and belief, and as to those matters I believe them to be true. I swear under penalty of perjury that the foregoing statements in this affidavit are true. The undersigned affirms that this document contains no social security numbers, dated this 18th day of June, 2014, signed Roger Hillygus. Subscribed and sworn to before me this 18th day of June, 2014, Michelle L. Novak, Notary Public, signed. Certificate of Delivery via eFlex. Pursuant to NRCP 5B, I certify that I am an employee of the law offices of Woodburn and Wedge, 6100 Neal Road, Suite 500, Reno, Nevada, 89511, and that on the 18th day of June 2014, I electronically filed the foregoing document with the clerk of the court system, which will send an automatic notice of electronic filing to the following: Stephen.C.Moss, Esquire, tod.torvinen, Esquire, Gordon Muir, Esquire, dated this 18th day of June 2014. Sharon Bradley. This is the Hillygus Family Trust restated, dated August 17, 1993. Prepared for H. Eugene Hillygus and Susan L. Hillygus. Law Offices of Michael B. Springer, P.C., Attorneys at Law. 9626 Prototype Court, Reno, Nevada, 89521. The Hillygus Family Trust restated, dated August 17, 1993. This trust agreement, made this 24th day of August 2011 at Reno, Nevada, between H. Eugene Hillygus and Susan L. Hillygus, husband and wife of Reno, Nevada, referred to as the settlers, and H. Eugene Hillygus and Susan L. Hillygus, husband and wife of Reno, Nevada, referred to as the trustees. Section 4. Write, amend, or revoke. The settlers may by written instrument, signed, acknowledged, and delivered to the trustees during the settler's life, revoke this agreement in whole or in part, and amend it from time to time in any respect except that the duties and compensation of the trustees shall not be materially changed by any amendment without the trustees' written approval. Settlers acknowledge that each has transferred separate and community property to the trustee. This transfer does not change the character of the property transferred to the trust, and either settler may remove his or her separate property from this trust at any time and for any reason. The trustee, upon demand, shall transfer the settler's separate property to him or her. 6. Death of surviving settler. 6.1. The settler, Herbert Eugene Hillygus, has one child over the age of 18 from a prior marriage, namely Randall M. Hillygus. Settlers purposely direct that nothing in this trust is to be distributed to Randall M. Hillygus, and he is deemed to have predeceased both settlers. The settlers have two children from their marriage, both over the age of 18, namely Roger E. Hillygus and Robin R. Renwick. Neither settler has any deceased issue at the time of the restatement of their trust. After the death of the surviving settler, the trustee shall hold and dispose of the trust property as follows. (9.1.1) Herbert Eugene Hillygus and Susan L. Hillygus are appointed as co-trustees. When both co-trustees are alive, both co-trustees acting jointly or individually may take action as authorized by the trust. 9.1.2 If either Herbert Eugene Hillygus or Susan L. Hillygus shall die or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Renwick shall serve as successor trustee. (13) Incontestability. If any beneficiary under this trust agreement shall, singularly or in conjunction with any other person or persons, contest in any court the validity of this trust agreement or of the will of either trustor, or shall seek to obtain an adjudication in any proceeding in any court that this trust agreement or any of its provisions, or that such will or any of its provisions is void, or seek to otherwise void, nullify, or set aside this trust agreement or any of its provisions, then the right of that person to take any interest given to him by this trust agreement shall be determined as it would have been determined had that person died prior to the date of execution of this trust agreement. In witness whereof, the settlers set their hands and seal, and the trustees have caused these presents to be executed on the day and year first above written. Settlers: Herbert Eugene Hillygus, H. Eugene Hillygus, signed. Susan L. Hillygus, signed. Trustees: Herbert Eugene Hillygus, H. Eugene Hillygus, signed. Susan L. Hillygus, signed. State of Nevada, County of Washoe, on this 24th day of August, 2011, Herbert Eugene Hillygus and Susan L. Hillygus, as settlers and trustees known or proved to me to be the same persons whose names are subscribed to the foregoing instrument, personally appeared before me and acknowledged that they executed the foregoing instrument freely and voluntarily for the uses and purposes therein expressed. Notary Public, Stephen.C.Moss. Encounter date, May 1st, 2013. Reason for visit, established care, new patient, possible dementia. HPI, Mr. Hillygus is 79 years old, who brought by his family because of concerns about his memory. His son accompanied him in the visit. The family noticed that he is repeating himself, social inappropriateness, like not considering other people's personal space, hugging everybody, and at one point, he had an obsession with some form of internet cards, which involved check writing. Diagnosis, dementia, primary, 294.20. Encounter date, December 12th, 2013. Reason for visit, medication problem. His son did bring in a letter from their attorney indicating a need for a letter supporting the fact that with his dementia the patient cannot take care of his own financial and legal affairs. I will be doing this letter as time permits for them. I will also be sending a letter to the DMV indicating that the patient should be withheld from driving due to his dementia at this time. Diagnosis, dementia, vascular, 290.40. Physician certificate with needs assessment. I, Kent Elliott, MD, am qualified in the following way to complete this form. Yes, I am a physician licensed to practice in the state of Nevada. Section 1. I examined Herbert Eugene Hillygus, an adult, on 12th of December 2013. This patient's diagnosis and condition is vascular dementia, 290.40, progressive. Significant memory impairment. In addition to examining the patient, I reviewed the following documents. Neurology evaluation. Adele A. Aziz, MD. I certify that this adult patient is unable to respond. Check all that apply. Yes, to a substantial and immediate risk of physical harm. Yes, to an immediate need for medical attention. Yes, to a substantial and immediate risk of financial loss. Describe immediate risk or need. No current or immediate risk. It should be noted that this statement by Dr. Kent Elliott clearly illustrates that there was no immediate risk. Does the patient present a danger to himself or herself? Yes. Does the patient present a danger to others? Yes. Why or why not? Risk of danger wandering, getting lost, risk for accident during driving. Has the patient been subjected to abuse, neglect, or exploitation? No. If yes, please explain. It should be noted that this proves, according to Dr. Kent Elliott's own determination, that Eugene Hillygus had not been subject to abuse, neglect, or exploitation. This is contrary to Robin.Renwick's claims that Roger was exploiting his father. Section 2. Does the patient need a guardian? Yes. Why? Unable to manage own fiscal or legal affairs. This part in Section 2 demonstrates that Eugene Hillygus was in need of a guardian to manage his affairs. Why was this ignored by Mr. Moss for so long? I declare under penalty of perjury that the foregoing is true and correct. Date, 12th of January 2014. Signature, Kent Elliott. The date here says 12th of January 2014. From the law offices of Michael B. Springer, PC. Dear Dr. Fredericks, I represent H. Eugene Hillygus. There is a matter pending in the probate department of the local district court which requires a competency evaluation of Gene and his wife, Sue Hillygus. Some of the issues that require the evaluation of a medical professional are: is Gene or Sue Hillygus competent to make decisions about managing their personal or financial affairs, including changing successor trustees and amending distribution of their estate? Sincerely, Stephen.C.Moss, Esquire. Signed. Dear Mr. Moss, thank you for referring Mr. Hillygus for competency evaluation. As you know, this is an 80-year-old gentleman who is trustee of the Hillygus Family Trust. Mr. Hillygus' wife has advanced Alzheimer's disease. He is currently living at the villas while his wife lives with their son and daughter-in-law in Dayton, Nevada. There is some concern over the possible financial exploitation by the designated first successor, Mr. and Mrs. Hillygus' son, Roger. The principal question put forth for this competency evaluation is whether Mr. Hillygus is able to function as sole trustee. Mr. Hillygus was accompanied by his daughter, Robin.Renwick, on 3 occasions: 4/2/2014, 4/29/2014, and 4/30/2014. Mr. Hillygus, along with his daughter, were interviewed during our first visit. Then he returned for cognitive testing and further interview on the second and third visits. The majority of testing was conducted on April 29, 2014. When he returned on April 30th, 2014, to complete testing, it was reported that he had visited urgent care that AM due to an onset of shingles overnight. Due to this event and the fact that he did not sleep well the night before, secondary to shingles pain, only a few tests were administered. However, during the first testing session, he was not experiencing any complaints or pain and discomfort. More inconsistencies with the dates again. This is becoming a pattern. Primary care physician is Dr. Elliott, MD. Review of Dr. Elliott's notes for January 14, 2011 indicates a history of prostate cancer, hypertension, hyperlipidemia, gout, hip replacement, and vascular dementia. He has seen Dr. Aziz and is currently under the care of Dr. Spivak, MD, a neurologist. His current medications include Namenda, and the 2011 note by Dr. Elliott reports albuterol, Cialis, amiperazole, levothyroxine, Avalade, allopurinol, Aricept, and verapamil. The financial situation is at question since both Mrs. Hillygus was declared incompetent to function as co-trustee and Roger is named as first successor trustee. Mr. Hillygus reported that he is currently sole trustee and cannot recall whom was named as first successor trustee. He reports his investment portfolio has not been depleted and valued at over $300,000. He understands that he can no longer manage his financial affairs, but is adamant that Roger not be named as trustee. He believes Roger has some brain damage from the accident that caused his disability, in addition to having exploited money that Mr. Hillygus believed was to be exclusively for the care of his wife. He reports that he trusts his daughter, Robin, and granddaughter in making financial and personal decisions on his behalf. According to Mr. Hillygus, Jean, after his wife's Alzheimer's disease began to progress, she became vulnerable to undue influence by their son Roger. She became completely controlled by their son Roger. At first, Roger was very helpful, according to Jean, coming over to help with meals, domestic chores, and his mother's care. Eventually, Roger moved into their home and continued to provide much-needed assistance. Jean is unclear how his son could move into their home while still being married. He also perseverates over his dislike for his daughter-in-law, Debbie, who he reports is uneducated, crude, and rude. It is a strong belief, and possibly delusional, that Roger turned my wife against me. According to Mr. Hillygus, Roger engaged in an insidious plan to influence his mother, take over the family estate, and kick Mr. Hillygus out of his own home while isolating his wife. He stated, "We had to have the police remove them." He reported that his son often had him sign blank checks and had him placed in a previous assisted living community against his will. According to his daughter, Robin, there was financial exploitation and emotional manipulation. She relates that Roger did move his wife, Debbie, in with Jean and Sue, and then relocated Jean out of the home. Mr. Hillygus reported that he cooperated with the move, but did not understand exactly what was happening at the time, then hated the place he had been moved into. I probably went along with it, but he, referring to Roger, made it sound so good. My whole life has turned around. He did not understand that he would be permanently removed from access to his wife, and is very resentful of the fact that he is not able to regularly visit his wife. When asked about plans for the future, Mr. Hillygus reported that he would like to stay where he is currently living and his wife should move into an Alzheimer's facility. He states, "I am getting older. I am moving into a dangerous area, cannot manage everything." He agrees that someone else should take over management of the trust and wants his daughter, Robin, to manage his affairs. I hope Robin will sell the house and get me out of the financial hole we are in. Although he is estranged from Roger, he still wants him included in the will because, after all, he is my son. He identified Darla, her husband, and his son Randy as trusted family members. He was able to name all his natural beneficiaries. He believes everyone is named in his current will and cannot name his current first successor trustee. Conclusion. Mr. Hillygus demonstrates very limited understanding of his current legal challenges. In my opinion, he was very likely subject to undue influence and financial exploitation by his son Roger. He does not demonstrate contractual capacity. He only demonstrates 2 of 3 elements of testamentary capacity. With regard to decisional capacity, his plans for the future for both himself and his wife appear logical and insightful. I was able to observe medical decision-making because he developed shingles after the first day of testing. Although he understood that shingles was a condition that needed treatment, he did not understand or remember the treatment and was very confused over the medications that were prescribed. In my opinion, Mr. Hillygus is unable to respond to a substantial and immediate risk of physical harm, to an immediate need for medical attention, and to a substantial and immediate risk of financial loss. It is also in my opinion that he has been subjected to undue influence, financial exploitation, and medical neglect by his son Roger. Signed, Deborah Fredericks. Deborah Fredericks, Ph.D., RNC, APN, PMH, CNS-BC. It is suspected that Robin Renwick was overmedicating Eugene during the time of the Deborah Frederick's competency evaluation in order to make him more amenable and susceptible to her undue influence.
Opposition in part to oral motion for the appointment of guardian ad litem. Memorandum of points and authorities. H. Eugene Hillygus, hereafter Gene, and Susan L. Hillygus, hereafter Sue, executed the trust agreement for the Hillygus Family Trust on August 17, 1993, attached hereto as Exhibit 1. Section 9.1.2 of the trust agreement provides as follows. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renwick shall serve as successor trustee. Although the language of this section is poorly drafted, Section 9.1.2 manifests Gene's and Sue's clear intent that in the event neither of them is unable to act as a trustee of the trust, then their son Roger H. Hillygus, hereinafter Roger, is to serve as the successor trustee of the trust. The family members and attorneys involved in this unfortunate family drama are all aware that Gene suffers from dementia and that Sue suffers from the effects of Alzheimer's disease. Sue is represented by Gordon Muir. Steve Moss previously represented Gene. However, pursuant to the June 12, 2014 letter attached hereto as Exhibit 1, Mr. Moss was discharged. Gene is currently not represented by counsel in this matter. Despite the fact that Roger has been the acting successor trustee, Mr. Moss set his previously filed petition regarding administration of revocable trust for hearing, purportedly on behalf of Gene, seeking to appoint Adam Clark as successor trustee. Roger's objection to this petition was filed on June 18, 2014. The petition was set for hearing on June 19, 2014. Mr. Moss conceded at the hearing that Roger was the successor trustee, but insisted, contrary to the terms of the trust, that Roger be removed as trustee. Tod.Torvinen, counsel for Robin Renwick, made an oral motion at the hearing for the appointment of a guardian ad litem on behalf of Gene and Sue. Roger hereby opposes that motion as to Sue because a guardian ad litem for Sue is not needed. Sue is adequately represented in this proceeding by Gordon Muir. The appointment of a guardian ad litem for Sue would unnecessarily increase the costs of administration. The limited trust resources need to be preserved for Gene and Sue, and given that Sue is represented by counsel, a guardian ad litem is unnecessary for Sue. There is no objection to the appointment of a guardian ad litem to represent Gene's interests now that he is not represented by counsel. Roger would agree to the appointment of John Smith or Kathy Breckenridge as guardian ad litem, whom the parties previously discussed for this role. Given the termination of Mr. Moss, he should not continue to represent either Gene or Sue in this matter. Mr. Moss represented both Gene and Sue when he prepared their estate plan, which is at issue here. When Gene and Sue's interests became adverse in 2013, Mr. Moss aligned himself with Gene without obtaining a waiver of the conflict. Then, in January 2014, only Gene executed an amendment to the trust agreement prepared by Mr. Moss, well after Gene had been deemed incompetent by his physician, Dr. Elliott. Given the termination of Mr. Moss by Gene, and given Mr. Moss's previous actions, Mr. Moss should be excluded from representing any parties in this case. Roger appreciates that Jean and Sue should be represented in these proceedings. However, the resources of the estate are limited and should be conserved to provide to Jean and Sue. Therefore, a guardian ad litem should be appointed for Jean, but not for Sue. The undersigned affirms that this document contains no Social Security numbers. Dated this 27th day of June, 2014. Date 6/12/2014. Dear Steve Moss, it appears as though you are not taking my verbal request to you over the phone, discharging you as my attorney. Seriously, let me refresh your memory about the events of that fall. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and I hand-delivered to your office secretary, Cynthia, an original hand-signed letter by Roger discharging you as the attorney representing me and the Hillygus Family Trust. At that time, we both told Cynthia to send us any and all personal property and the complete file along with the final bill. You called me the next day and we spoke about this, and I informed you during that phone call that I no longer need or wanted you to represent me or the trust. You told me that pay the final bill would be $2,000. I am confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter. I am, however, disappointed that you are continuing to represent me after we mutually agreed to terminate our relationship. I realize that you believe me to be incapacitated and that you think you are protecting me from my son, Roger Hillygus. Nothing could be further from the truth. He is the successor trustee and the one I have always wanted to be placed in that position. So please consider this your official notice discharging you as my attorney. You are to cease and desist from any further actions, hearings, or petitions with the court on my behalf or by representing any family member. Respectfully yours, Herbert Eugene Hillygus. Recommendation for order assuming jurisdiction over trust, order setting pretrial conference. The commissioner held a duly noticed hearing on June 19, 2014, upon the petition regarding administration of revocable trust filed by H. Eugene Hillygus through his counsel, Stephen.C.Moss, Esquire. Counsel Moss appeared at the hearing. Also appearing at the hearing were the following additional interested parties: tod.torvinen, Esquire, representing robin.Renwick, who joined in the petition; Sharon Januzzi, Esquire, representing Roger E. Hillygus, who opposed the petition; Sharon Januzzi, Esquire, representing Roger E. Hillygus, who opposed the petition. Not appearing was Susan Hillygus, co-settler of the trust, nor her counsel, Gordon R. Muir, Esquire, although the court is informed that he is still counsel for Susan Hillygus. The matter is contested. The commissioner therefore scheduled the parties for a pre-trial. The matter is contested. The commissioner therefore scheduled the parties for a pre-trial conference on July 1st, 2014 at 4 p.m. before Department 4 of this court, the Honorable Connie J. Steinheimer presiding. The commissioner made the following additional recommendations. The court assumes jurisdiction over the Hillygus Family Trust, dated August 17, 1993. The court declines to confirm the appointment of any successor trustee, although the record indicates that the same may have become necessary based upon the incapacity of both settlers, H. Eugene Hillygus and Susan L. Hillygus. Instead, the pretrial conference date was expedited so as to allow these issues to be addressed soon, if necessary. The court further declines to act upon the oral motions to appoint a guardian ad litem for either settler, and instead allows the opposing party, Roger E. Hillygus, to file his written opposition to that motion. Nothing in this portion of the recommendation, however, constitutes a finding that would bar a party from seeking further relief in this area or in continuing to pursue the pending petitions for appointment of adult guardians if the same becomes necessary or appropriate. Take note of the parcel number here, 552-171-04. This will become relevant later in the timeline. Homestead document dated 11/05/2015, 12:06:37 p.m.
February 20th, 2017, the request for submissions of motion for dismissal with prejudice and award of attorney fees for fraud upon the court, originally filed August 3rd, 2016. Respondent repeats allegations that Mr. Torvinen, Ms. Renwick, and Mr. Moss colluded to improperly initiate PR 14-00025. Ms. Renwick and counsel inappropriately utilized the trust funds. Ms. Renwick is unfit to serve as a guardian, and respondent disagrees with the stipulation placed on the record on February 23rd, 2015 by respondent's former counsel. April 18th, 2017, order striking request for submissions, order holding decision in abeyance, notice vexatious litigant. The court noted the motion repeats many of the allegations set forth in the December 17th, 2015 response. The court declined to conclude res judicata, barred the motion in the light of ongoing appeal. The court stated it may entertain a motion to deem respondent a vexatious litigant in the event of future meritless filings.
According to the state's claim, Mr. Roger Hillygus had no legal standing or claim in regards to his filings.
This is completely false. As we have already established earlier in this timeline, he had absolute legal standing and the right to his due process.
The state further claims Roger Hilligus's filings were frivolous and intended to harass the co-guardians, delay, and obstruct proceedings.
This claim is false. Mr. Roger Hilligus's filings were not intended for any other purpose than his right to due process, which was being deprived by the state. This is contrary to the judge's oath of office, which states they must uphold and defend both the state and U.S. constitutions.
The court denied 2 previous attempts to deem Mr. Roger Hilligus a vexatious litigant before approving the third, and the state further claims that such accommodation is no longer merited.
This is completely false. The court has repeatedly withheld discovery, exculpatory evidence, and actively deprived Mr. Roger Hilligus of his right to due process under the state and U.S. Constitution, respectively.
In Section 3 of the approved vexatious litigant ruling, the state admits they forced Roger to incur the financial cost associated with Mr. Torvinen's filings in response to Roger's filings from January 10th, 2017 through March 1st, 2018.
This is extortion and completely outside the established rules and procedures regarding judicial conduct in the context of applying the right of due process. It should further be noted that tod.torvinen and Judge Francis Dougherty were colleagues at WashU Legal Services for 20 years prior to this court hearing. This shows malice of forethought, collusion, and conspiracy to commit extortion by a pre-existing established conflict of interest in regard to tod.torvinen and Judge Francis Dougherty, and establishes patterns and habits and traditions which are in violation of the Constitution. It also should be noted that tod.torvinen's father was a judge, and this further speaks to the patterns of habits and traditions due to nepotism.
#29. Department D12. Event. Request for submission. Scheduled date and time. August 4th, 2016 at 10:51 a.m. Extra event. Text. Motion to disqualify the Honorable Francis Doherty from hearing the consolidated cases of the Hilligus Family Trust. Event disposition S200. September 9th, 2016. Filing 1023. October 17th, 2018. -1310E. Case Appeal Statement. Additional text. Corrected Case Appeal Statement. Transaction 6932265. Approved by no review. So no review. October 17th, 2018 at 10:25:46 a.m.
1,023 separate filings is what it took Roger to get Dougherty to retire early after removing him from the trust, then deeming him a vexatious litigant.
Case number PR 14-00025/GR14-00159. In the matter of the Hilligus Family Trust, dated August 17th, 1993. In the matter of the guardianship of the person and estate of Susan L. Hilligus. Notice of right to a jury being applied to this case per the Nevada Constitution, Article 1, Section 3. Inviolate forever.
Sec. 3. Trial by jury, waiver in civil cases. The right of trial by jury shall be secured to all and remain inviolate forever, but a jury trial may be waived by the parties in all civil cases in the manner to be prescribed by law, and in civil cases, if 3/4 of the jurors agree upon a verdict, it shall stand and have the same force and effect as a verdict by the whole jury, provided the legislature by a law passed by a 2/3 vote of all the members elected to each branch thereof may require a unanimous verdict notwithstanding this provision.
Forever. Legal arguments. Arguments why the state, the court, and the petitioners feel they are justified and compelled to keep Susan L. Hillygus incarcerated and isolated in a private locked facility, denying a mother-son relationship. Case number GR 14-00159. Second Judicial District Court, Probate and Guardianship Court. Removal of trustee and power of attorney. Judge Commissioner, Judge Egan Walker, Department 7. Reference opposing position statements. Note, the court has discretion to furnish their own jury. As previously noticed, this case shall be decided by a jury per Article 1, Section 3 of the Nevada Constitution. This right is inviolate forever. The Second Judicial District Court has declined to provide a jury as formally requested by the Hillygus family, so that responsibility falls to the son, Roger Hillygus, per the 10th Amendment. At any time, the court may schedule a jury hearing which would render a jury provided by We the People Court Services void. Nothing in the NRS statutes in Nevada District Court rules prohibit the court from providing a jury. 2. Petitioners assert that the son is dangerous, mentally ill, and exploiting his mother. The petitioners have failed to prove any mental defect or any of their slanderous accusations. Petitioners, when ordered, produced zero discovery evidence. There is no opinion, testimony, or affidavit by a licensed healthcare provider in this case. This case is ripe for due process, which is lacking in this case. 3. Petitioners assert that the son who is residing in the familial home caring for the parent is unfit and or incapable of providing care and supervision. 4. The Nevada Attorney General has until c.o.g. Wednesday, June 5th, 2019, to propose additions or subtractions from paragraphs 2 and 3. No response shall be considered a consent with the arguments made herein, and the evidence shall be presented immediately to a jury. 5. Petitioners have failed to provide any clear and convincing evidence. Respectfully submitted, S. Roger Hillygus, Roger Hillygus, son, retired Nevada Public Safety Civil Servant. This document is being submitted with guidance from We the People Court Services. https://www.wtpcs.org. Thursday, May 30th, 2019. Liberty and justice for all. I hereby certify that on this 30th day of May 2019, I served a copy of the following documents: Declaration of Jury Process by eFlex mail, sufficient paid FCCS and or by hand delivery as follows. 1. Attorney tod.torvinen, 232 Court Street, Reno, Nevada, 89501. 2. Attorney Keith Tierney, Esquire, 527 California Avenue, Reno, Nevada, 89501. 3. Attorney Ryan Earl, 548 West Plum Tree. 3. Attorney Ryan Earl, 548 West Plum Lane, Suite B, Reno, Nevada, 89509. 4. Attorney David Spitzer, 199 South Arlington Lane, Reno, Nevada, 89502. 5. Gunderson Law Firm, John Funk, 236 Warren Way, Reno, Nevada, 89502. 6. Professor of Constitutional Law, Martin Lynch, WTPCS, 1120 West Broadway Road, Apartment 55, Tempe, Arizona, 85282. Case number GR 14-00159. Second Judicial District Court, Probate Court. Removal of trustee, removal of power of attorney, POA. Judge Commissioner, Judge Egan Walker, Department 7. Reference opposing position statements. Note, the court has discretion to furnish their own jury. Legal argument. As previously noticed, this case shall be decided by a jury per Article 1, Section 3 of the Nevada Constitution. This right is inviolate forever. The Second Judicial District Court has declined to provide a jury as formally requested by the Hillygus family, so that responsibility falls to the son, Roger Hillygus, per the 10th Amendment. At any time, the court may schedule a jury hearing, which would render a jury provided by we the people, court services, void. Nothing in the NRS statutes or Nevada District Court rules prohibits the court from providing a jury. 2. I have submitted exculpatory evidence from licensed neurologists and physicians regarding my parents' mental capacity. I have provided notarized trust documents that my mother and father placed me, their son, in a legal position of authority. I am the legal successor trustee of their trust, guardian, and I am the legal exerciser of medical and financial power of attorney for their benefit. I have been denied due process and been illegally removed. I am a 52-year-old professional firefighter, emergency medical technician, EMT, who retired, who graduated with a degree in business from University of Nevada, Reno. All of this and other exculpatory evidence is being suppressed by the petitioners. I have been with my wife for 22 years, with 3 children and 4 grandsons. I have never been criminally arrested or indicted. I have faithfully served my state as a firefighter and public servant for 30 years. 3. My wife and I engaged the help and support of the Washoe County Senior Services, Meals on Wheels, Retired Senior Volunteer Program, and the UNR, University of Reno, Sanford Center, Alzheimer's Center, for training with psychologists. We even attended seminars regarding proper care for my parents. Every member of my extended family are gainfully employed and married. Never has there been any evidence of abuse, neglect, or harm regarding my parents while under our care. Evidence of abuse does exist while under the care of the petitioners. Exculpatory evidence including bank statements, medical records, reports have been suppressed by the petitioners and the court. The only people being financially exploited are Susan L. Hillygus, the Hillygus Family Trust, and me, her son. I purchased airline tickets and other incidentals over time as trustee and power of attorney, POA, for the benefit of my mother for a family vacation in California to visit her family. Petitioners, in retaliation to my legal authority, have filed false statements, perjured testimony, filed false police reports, filed false medical reports, committed theft, had me falsely arrested, illegally searched, and seized my personal property without legal authority. 4. This case calls out for due process. The personal cost to date to my family for litigating this frivolous action, including the items of stolen property, exceeds $700,000. The cost to Susan J. Hillygus and her trust exceeds $1 million. 5. This, along with other exculpatory evidence and reports, will be presented to the jury. All evidence shall be redacted as required by 42 U.S.C. United States Code, subsection 5106A. 6. The state, the court, and the petitioners have failed to meet the burden of proof as required by law, as no clear and convincing evidence exists in this case against Mr. Roger Hillygus, although clear and convincing evidence does exist regarding illegal actions of the petitioners, guardians, and appointed court insiders. A jury is being applied to this case per Nevada Constitution, Article 1, Section 3, inviolate. Opposing position statements A and B. A. why the state is compelled to remove the son as trustee, case number PR 14-0025, and must institutionalize and isolate mother by court order, case number GR 14-0159. The Second Judicial District Court has declined to provide a jury as formally requested by the Hillygus family, so that responsibility falls to the son, Roger Hillygus, per the 10th Amendment. At any time, the court may schedule a jury hearing which would render a jury provided by We the People Court Services void. Nothing in the state statutes or court rules prohibits the court from providing their own jury. If opposing counsel disagrees and wishes to change the following items of which son is being accused, then those changes must be submitted by C.o.g. Friday, June 28, 2019. Whatever accusations against son result shall be submitted to the jury thereafter. 1. Son is accused of squandering funds, $400 hunting equipment, $400 plane tickets for family trip to California with parents. Both occurred prior to son becoming the trustee. 2. Commingling funds, $1,300. Son's disability check was cashed at father's bank. 3. Son did not have a house to live in. 4. Son was not disabled and was falsely collecting disability. 5. Adult Protective Services regarding complaint of mother's misidentification while she was in the hospital. 6. Registered nurse R.N. Deborah Fredericks wrote an 11-page report accusing son of medical and financial abuse. Nurse Fredericks did not file a sworn affidavit, nor was she ever examined under oath. 7. 4 complaints made to sheriff that son was stealing from parents. No charges were brought. All complaints were made by the petitioner accusing son of crimes and misconduct. Closing arguments. Son is dangerous and unfit based upon allegations listed above. A. Why no clear and convincing evidence exists which compels the state to protect surviving mother from her son. To remove the son as trustee, case number PR 14-0025, and institutionalize and isolate mother by court order, case number GR 14-0159. 1. Squandering funds. $400 plus $400 equals $800. The lawyers have charged $500,000 to litigate this case. 2. Commingling funds, $1,300. Son cashing his check at father's bank is not commingling. The accusation is nonsense. Son was never accused or charged with a crime. 3. Son's residence was, has been, and still is as listed above. Refinancing and homelessness are not the same thing. 4. Son was injured on the job and determined to be disabled by an MD, medical doctor. Allegations to the contrary was investigated and determined by the state AG, Attorney General, to be false. 5. Complaint to Adult Protective Services regarding mother's misidentification while in the hospital was investigated by Adult Protective Services, APS, and determined to be frivolous and false. 6. The report by Nurse Deborah Fredericks was created based upon hearsay evidence. Son was never interviewed. This is in keeping with other reports fabricated by Nurse Fredericks in numerous similar cases. Nurse Fredericks has a $900 financial conflict of interest. 7. As the trustee, son moved household furnishings to where they were needed to provide for mother. The lawyers have charged over $500,000 to litigate this dispute. Everyone is being impoverished except for the 20 lawyers who have worked on this case. Therefore, the only people who can rationally be accused of stealing are the lawyers. Closing arguments. Son is a 52-year-old professional firefighter, EMT, emergency medical technician, retired, who graduated with a degree in business from UNR, University of Reno. Exculpatory evidence is being suppressed. Son has never been criminally charged or arrested. Son was a firefighter and public servant for 30 years. Son asserts that the purpose of this litigation is for the lawyers to plunder mother's estate. This is based on the evidence of the $500,000, which has already been consumed by the lawyers and their friends. Mother still owns her home, but the lawyers are trying to sell that, so they may then plunder everything. In addition, both Son and his sister have been manipulated into this endless conflict, resulting in financial ruin of everyone, both parents and their children. Please see 18 United States Code, subsection 1341, and 18 United States Code, Chapter 96. Son seeks a jury verdict that overturns all judicial orders that nullify the original trust documents and powers of attorney and appoints lawyers or other third parties to these two cases. Case number PR 14-0025, case number PR 14-0025 / case number GR 14-0159. The lawyers will then be free to plunder the estates of other parents and their children. The jury is being processed in this case per the attached notice to judges. We the People Court Services, Liberty and Justice for All, https://www.wtpcs.org, June 24th, 2019. Notice to judges, limited supplemental jury process in all state, civil, family, juvenile, guardianship, and probate courts, self-effectuating. Absolute power corrupts absolutely. So the founders created a system of intricate checks and balances. Did the founders forget about judges? Where is the limit of the power of any judge to 1, take your children, 2, take all your money, 3, throw you in jail? It's right here. 1, command authorities. 1.1 Nevada Constitution, Article 1, Section 3. Right to a jury is inviolate. All states use inviolate. 1.2 U.S. Constitution, 7th Amendment. Right to a jury is preserved, shall not be re-examined. 1.3 U.S. Constitution, 10th Amendment. Where government has discretion, rights become self-effectuating. 2 supporting authorities. 2.1 State statutes. No law prohibits juries in these courts. If it did, it would be irrelevant. 2.2 Federal and state rules of civil procedure, 38 and 39, affirm jury rights are inviolate. 2.3 Family, juvenile, and probate rules of procedure contain no prohibitions to a jury. 2.4 Federalist 83. Juries are the check on the power of civil courts meant to prevent corruption. 2.5 Case law. Minneapolis and St. Louis Railroad Company versus Bombolis, 241 United States 211, 1916. United Gas Public Service Company versus Texas, 303 U.S. 123, 1938. Affirm the court's discretion to furnish a jury. There is no prohibition of juries in civil courts. Any notions of prohibition are false. 3. Jurisdiction. A. The courts, and then B. The people. WTPCS.org. We the People Court Services. 10th Amendment. The people prefer a bench trial. It is efficient and justice is usually rendered without intervention. 3.1. unjust infringement on parental or familial rights, presumption of shared parenting. 3.2, unjust taking of property or money by judicial order. 3.3, unjust or excessive incarceration or detention. 3.4, gag orders. The purpose of the First Amendment is to criticize the government. For any of the above lingering matters, a litigant should petition the court to schedule a hearing where the people exert their just authorities over these matters via a jury furnished by the court. 3.5. At the court's discretion, the people via WTPCS, We the People Court Services, may furnish their own juries in a scheduled court hearing or otherwise per rules established by the people to best preserve due process. 3.6. WTPCS, We the People Court Services, has discretion to provide or not provide a jury based on the merits of the case. Judges are encouraged to apply findings of fact and conclusions of law to judicial orders so that juries are more likely to affirm their orders. 4. Limits on the power of a jury. Court hearings conducted with a jury are subject to normal court rules. Jury verdicts rendered outside of a court hearing may only either affirm the judicial order or strike down a judicial order and provide advice to the court. The verdict may be filed into the case. This supplemental jury panel may not change the order or otherwise make law. 4.1. The judge may do nothing if the order was affirmed or nothing was filed into the case. 4.2. Revise the order to the satisfaction of the parties or in keeping with guidance from the jury. 4.3. Schedule a hearing with a jury whose verdict would then be superior. 4.4. Defy a jury verdict which is the just and guaranteed authority of the people to govern themselves, creating a breach of the Supremacy Clause and the oath per Article 6, Clauses 2 and 3. No judge is required to be a judge and may resign at any time. This would necessitate notifying the governor of a vacancy and seeking a replacement be appointed. Notification of POTUS, President of the United States, to avoid a federal appointment since the judge has resigned and is no longer authorized to exercise judicial powers. Law enforcement, the sheriff, may not enforce orders issued by a former judge or anyone else who is not a judge. The new status of the judge shall be made public so the people may avoid being subjected to a judge who openly defies their oath and the Constitution. These remedies shall become effective on the date indicated in the notice. 5. This process is designed to enhance the confidence of the people in their judiciary with minimal cost and intervention. Most judges are competent and just, and their docket is expected to decrease as cases settle more readily, as opportunities for corruption are reduced. This has been our experience. Over time, a small number of judges may end up finding something else to do. Case number PR14-0025, case number GR14-0159, Department number 7, in the matter of Hillygus Family Trust, dated August 17, 1993, PR14-0025, in the matter of the guardianship of the person and estate of Susan L. Hillygus, mother, GR14-0159. Jury verdict and options available to the court. Honorable Judge Egan Walker. This is notice to the court that a jury has examined the evidence which was approved by the opposing counsels via acquiescence and they have determined and stated in their unanimous verdict that there is not clear and convincing evidence that familial rights must be terminated to protect the parents, and that all orders of this court that interfere with familial rights, as stated in the Hillygus Family Trust documents, are void and unenforceable. Options: 1. Order the immediate release of mother to son's custody and conform to all trust documents as ordered. 2. Convene your own jury to decide this matter. No law prohibits a jury. 3. Or provide findings of fact and conclusions of law explaining how this court is not subject to the authorities listed in paragraphs 1 and 2 of the attached notice to judges. All other legal authorities are subordinate to the Nevada Constitution, inviolate, and the jury has made their decision. The court has until close of business, Friday, July 26th, 2019, to respond to preclude actions described in subsection 4.4. Affirmation: Nevada Revised Statutes 239, no Social Security numbers are anywhere. Dated this 19th day of July, 2019. Signed, Roger Hillygus, son. Case numbers PR 14-0025 and GR 14-0159. Second Judicial District Court, Nevada, County of Washoe. Guardianship and Estate of Susan Hillygus. Judge Egan Walker. Reference documents for and against termination of familial rights dated June 25th, 2019. Documents meet the confidentiality requirements of 42 United States Code subsections 5106A. This court has been duly noticed of defendant's right to have a jury decide this case. The judge declined to furnish a jury, leaving that responsibility to defendant per the attached notice to judges. The above-mentioned documents have been presented to an 8-person jury panel, and they have produced a unanimous verdict as follows. 2. Jury verdict. The state has not met the standard of clear and convincing evidence that the son is dangerous or abusive to his parents, such that the state is compelled to intervene in this family. Wherefore, all orders that diminish the force of law established by the family trust documents are void and unenforceable. This verdict is effective immediately and may be overturned only by a jury provided by the court under its authorities per Article 3. The court has discretion to utilize its own jury at any time. The right to a jury remains inviolate regardless of the results of the court's discretion. 3. This court now has the discretion to choose any of the options in Section 4, page 2 of the attached notice to judges. 4.2 issues orders that conform to jury verdict. Return mother. 4.3 convene the court's own jury. 4.4 deal with defiance of the Constitution noted. 4. Seventh Amendment. No fact tried by a jury shall be otherwise re-examined in any court of the United States. No place does it say, quote, a judicial order may not be re-examined by a jury. Only the word, quote, inviolate controls in this matter. Notice of judgment. The encumbrance of 2685 Nob Hill Drive, Reno, Nevada, 85906. Presiding Judge Egan Walker. This is notice to all concerned that the real property, 2685 Nob Hill Drive, Reno, Nevada, 85906, is subject to sole and exclusive ownership by the Hillygus Family Trust, of which Roger Hillygus is the sole successor trustee. All orders to the contrary, and prior to the verdict rendered on July 11, 2019, are void and unenforceable. Any actions or transfer of title to this property without the current expressed written consent of the trustee, Mr. Roger Hillygus, may either be negotiated to the satisfaction of the trustee or a satisfactory resolution shall be adjudicated in a court of law.
Absolutely. Okay. She put me in charge of her as her power of attorney. I'm her successor trustee to her trust.
Okay.
I'm her son.
Okay.
I've cared for her already, and I'm going to continue to care for her. I'm retired fireman.
Okay. Perfect. How long has she been in the care facility?
3 years.
3 years.
After I had everything in order.
That the facility is not going to want you to take her?
A little bit.
Okay, why is that? That's what I guess I'm getting at.
Because when I was there visiting her with a witness, it was all videoed.
Gotcha.
I was holding her hand, like loving my mother.
Yeah.
And they said, "You have to leave. You're upsetting your mother." And I said, "What are you talking about?"
Okay.
And they said, "Well, we've called the police." And I'm like, "Why? I'm sitting here with a witness. It's videoed. She's loving that I'm there holding her hand. I'm not upsetting her."
Yeah.
And I cared for my mother for 3 years.
Absolutely.
And I've lived with her for, a lot of my life, and I want to continue to care for her.
Okay. Perfect. Did she voluntarily go into the care center, or was she placed there by somebody?
They placed her in there.
Who placed her?
The guardian that's been now removed from the jury verdict.
Oh, okay. So there was another guardian involved.
There was one, yeah.
Okay. And they placed her there.
Yep.
And so was there a dispute between you and the former guardian about who should have guardianship of your mother?
There was false allegations made against me, but they were investigated, and I was proven to be
Gotcha.
There was no allegations that were shown to have affected me.
Okay.
It was investigated. I wasn't convicted. I wasn't arrested. I didn't do anything wrong. I'm not a criminal.
No. Okay.
I'm a
So
retired
what's the
public servant.
judgment that you got? What's the judgment say?
It says that I'm her. The original trust documents are back in place, which I have, and the original power of attorney, and that all the orders from the court are null and void and unenforceable. The jury verdict controls the position that I have with respect to taking care of my mother.
And where is Stone Valley, just so I know in case they call us for some reason? Alright, so what brought you down here? I mean, I understand you want a stable standby. Obviously, we don't do that unless we have some reason. Because we're not here to enforce these court orders. I mean, we don't. And why we would even get involved, I have no idea. Normally, the civil deputies over at the courthouse, if there's a judgment from the court, it gets handed to them, and the civil deputies handle it. So I don't know. I mean, the police department, we don't enforce any civil orders, period. And obviously, you're there to get your mother.
I'm trying to come to you guys to explain to you that I've got all the authority to do this.
Like I said, we're not involved. We don't get involved in civil judgments, period. Either side. I don't even care what the judge ruled. If the judge ruled that you have full power to walk in there and take the whole facility, that has nothing to do with us. That's a civil judgment. The government has no interest in that, so why would we get involved? So what I'm saying to you is if you get up there, I would bring all your documents. I wouldn't just walk in there and grab her. I'd go see the management of the facility, show them your documents, explain to them rationally, here's my plan, here's what I'm doing, this is why I'm doing it, this is all the documentation that I have. Can you help me fulfill the orders of this so I can get my mom?
Every time I'd gone to see her, there was something that she wasn't being taken care of.
Okay.
And one-on-one care of a son versus one person with 17 people.
Oh, I hear you. Absolutely.
Every time I went there was issues with my mother not being cared for.
Yeah.
So, with Susan's meds, is there anything on this list that, if not taken as prescribed, is life-threatening?
Just Ativan, and Risperdal.
Can risperidol cause death in the elderly? Risperidol has been shown to increase the risk of death in elderly patients with dementia. More elderly dementia patients have died from pneumonia, cardiac failure, and stroke, while risperidol and the increased risk were not related to the dose amount or how long the medication had been taken. Though the exact cause is unknown, patients with dementia may be more at risk as they are unable to report severe symptoms. Because of the number of deaths, the FDA required that a black box warning be added to prescribing information for Risperdal. A black box warning is the most severe warning that can be issued by the FDA and requires that information is printed at the top of prescribing information surrounded by a thick black border.
And this one is for the anxiety.
Well, nobody's ever died from anxiety that I know of, but
No,
as
I
far
don't
as
think
any,
so. No. Yeah, that's also. It is. Yeah, this is the opposite vitamin D. I don't think so.
yeah, that's what I didn't think so. I just wanted to double check with you.
No.
Okay.
This is just are for anxiety.
Right. Okay. Thank you.
I need you to call down there. 925,000. Try to get back through to his medical assistant. I need a prescription of lorazepam for that resident.
2:30.
Lorazepam. Important warning. Lorazepam may increase the risk of serious or life-threatening breathing problems, sedation, or coma if used along with certain medications. Tell your doctor if you are taking or plan to take certain medications for cough or for pain that contain opiates. Example: codeine, hydrocodone, morphine, oxycodone, tramadol. Your doctor may need to change the dosages of your medications and will monitor you carefully. If you take lorazepam with any of these medications and you develop any of the following symptoms, call your doctor immediately or seek emergency medical care immediately: unusual dizziness, lightheadedness, extreme sleepiness, slowed or difficult breathing, or unresponsiveness. Be sure that your caregiver or family members know which symptoms may be serious so they can call the doctor or emergency medical care if you are unable to seek treatment on your own.
At first I thought that he would do that because that's what he's done in the
To have
past.
them fax
To try to-
us a script for her so that we can get her some medication so she calms down.
He is married?
He's aggressive. Do you know that the sheriffs had to remove him with the SWAT team from this house?
From your mom's house?
And the sheriffs wouldn't do it without a court order because he threatened that he had guns. And he does have guns. So if they go out to Dayton, they need to be aware what they could possibly be walking into.
And we'll let them know.
You know, what's going to happen to my mom after?
Well, she's not on her meds. She's not going to have her meds. She's not going to get changed. I mean, there's crazy stuff going on. This is a copy of what he said.
No, she's
barely walk.
So he was dragging her. Not literally dragging her,
I'm
but
surprised he didn't pick her up.
pulling her.
Yeah, I'm shocked.
My
It's
mom,
assigned to a detective.
okay, but do you understand that my mom's life is in danger right now? In danger.
How?
How?
How? She's with your brother.
Have you heard all the stories that we've been going through? That
I understand he has. He may have some.
medications, so you
Okay.
believe that he's
There-
not a hazard.
None of your mother's. No, she doesn't. All of her. No, she doesn't. Because I just talked to the med tech because I got a list of her meds, and I confirmed with the med tech because all of her meds are primarily for anxiety, mental health. It's not for. There's nothing physical that if your mom does not take medications, she's going to die from. And I confirmed that with the med tech.
This is the hearing where they got the emergency TPO, which they used as a false basis for persecuting Roger without any recourse of due process and selling the home the day after Roger rescued his mother from Stone Valley Care Facility.
You were aware of what happened, right? Here's a little more. Apparently, he shows up with another goon, and he says, I'm signing Alice out. He goes and gets Mrs. Hillygus, and there's a witness who sees them pulling her, shoving her across the parking lot. He was pinged in Truckee, apparently. Was that this morning or yesterday?
Yesterday.
And this, really, it's a crime. It's a crime of kidnapping. It could be a crime of, that's a Class B felony, probably. Isolation, elder abuse. Well, problematic. Anyway, I don't want to get sidetracked on that. We're here to confirm the property. I'm sorry I interrupted you. the title company is balking at a close any sooner than 30 days because they're afraid that Mr. Hillygus is going to appeal. And I think this is what I'm about to say is true is a matter of law, that upon sale to a bona fide purchaser in good faith, his cause of action, if any, from this sale is against the trustee and not against the real property. Would you be willing to add that to the order? I'm hoping it gives the title company some comfort so we could get this thing closed sooner.
Any objection to that, Mr. Spitzer?
No, Your Honor.
I would likely sign such a thing.
Robin,
Before we go too
Okay,
far down
sorry.
this, I just want to make sure you don't have any quarrel with this, Mr. Spitzer.
I have no quarrel with that, Your Honor. You do have immediate authority under NRS 159.334 to issue a no contact order under the guardianship statutes.
Mr. Earl?
My only additional thought is under NRS 159.305 that you're dealing with just general exploitation, potential abuse, and so forth, and under those statutes, then likewise the guardian would have authority or an interested party.
And my thought about a domestic violence protection order is this, is it's registrable. In other words, it'll go into a state and national database. And it may have more legs, for lack of a better term, than simply, I of course order that Mr. Hillygus have no contact with a protected person in this case. And that is pursuant to Chapter 159. But let's see if we can establish whether or not there's testimony to warrant a domestic violence protection order. So, ma'am, would you kindly stand, raise your right hand, and take the oath of a witness?
Do you solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
And they allowed him out thinking that he was the son and he was allowed to take her out, even though in her file he is not. His name is not on the list of people that are allowed to remove her from the facility. There's a picture in the back room of him, but it didn't look like him.
Let's test that theory with the picture she is referring to and the Reno PD body cam footage of Roger asking them for a civil standby. Let's see what we find with what we have. He sure does look the same to me in the picture as he does in the body cam footage.
Let's move now next to the accounting. With that clarification going forward, I'll approve the accounting.
Your Honor, this has been a long tortured road. I understand that. The amounts are high, but in light of the nature of the work required, I don't have an objection.
Yeah, I note that fiduciary services fees includes invoices for almost $2,000 of fees just to deal with Mr. Roger Hillygus, for example.
And I would suggest, Your Honor, that ultimately the guardian of the estate might attempt to recapture those.
I agree. Let me take an aside in this way. I'm deeply concerned about Miss Hillygus and her welfare. I dare say I couldn't overstate your concern. It's apparent that Mr. Hillygus has some active mental health issues going on. The filings I'm receiving now are so far removed from reality as to be almost unintelligible, but cause me concern as to his stability. What I mean by that is I intend, if the law would allow me, to retax that 1947 to Mr. Hillygus, but I don't want to push him or anyone else even farther into delusion or psychosis or whatever else may be going on, and so I just intend to be thoughtful about it. Is my only comment.
Your Honor, in my involvement in this case and long observation of Mr. Roger Hillygus, I'm not prepared to reach the same conclusion you are regarding his mental state. He is quite a calculating man. He has adopted the constitutionalist type of attitude that those who've practiced in criminal law have seen over the years in people that are perfectly capable in every other way. In regards to those, Your Honor, I think a cause of action to recoup them by the guardian at some later date might be the most appropriate way to do it. Again, anything we do here is going to be subject to some kind of appeal.
Of course.
But under NRS 200.310.2, A person who is willfully, without authority of law, seizes, takes, carries, or kidnaps another person is guilty of Class B felony. To find here in open court today that there's PC with regard to that criminal statute, Class B felony kidnapping.
I think I would do a disservice to the process in this case if I were to step in out of order any more than I already have. Let me be more clear. It's fairly unusual for a district judge sitting with family division jurisdiction, as I do in this guardianship area, to sua sponte issue a protection order. It's been done before. I've done it before. I've never seen a successful challenge to it, and so I believe it's within the jurisdiction of me as a district judge. There is a process, however, in the criminal side. You know, I am now a criminal judge. The law enforcement authorities are going to have to approach the district attorney's office to seek either a warrant for the arrest of Mr. Hillygus, or they will detain and arrest him on allegations of probable cause. It would not be appropriate, I think, for me to opine at this juncture as to whether or not there is adequate probable cause. I just think that would be stepping outside the bounds of my role at this time.
When this first happened yesterday, my clients, both of them, ran into the following milieu. Oh, it's just between a brother and a sister. This is a civil matter, when really it's not. And that's what I'm trying to overcome here. I just want you to understand that, where that's coming from.
Well, I can tell you that in my view, there are a variety of paths that could be taken to recover the person of Miss Hillygus. More specifically, what I mean is I believe there could be an analogous action for a retake warrant, in the way that if a parent secretes a child in a contested custody proceeding, there is a process to allow me to issue a warrant to include the arrest and detention of the parent or the bad acting parent who is...
Wow, talk about violating your judge's oath of office. So much for avoiding the appearance of impropriety, and so much for upholding the state and federal constitution, eh?
It would be a UCCJEA.
Correct.
Okay, and there's an equivalent in...
well, the UCCJEA applies in Chapter 159 cases by definition.
Right.
And so there may be a mechanism for a retake warrant, as it were, related to the person of Ms. Susan Hillygus. Apart from that, law enforcement is very aware of this case, I can tell you. It would appear to me there is an active investigation. It would appear to me there is some reason to believe that Mr. Hillygus has kidnapped, falsely imprisoned, and or unlawfully detains the person of Susan Hillygus.
Okay. I think that's all I have before you today, Your Honor.
Anything else, Mr. Spitzer?
No, thank you, Your Honor.
Or Mr. Earl?
No, thank you.
Thank you all very much for your time. Ladies, good day to you.
Thank you very much.
You're welcome.
Jurisdictional disputes regarding children in Las Vegas, helping families throughout Clark County. In Nevada, custody disputes are governed by the Uniform Child Custody Jurisdiction Enforcement Act, which is commonly referred to as the UCGA. The UCGA determines whether or not the Nevada court has the ability to consider custodial disputes. Basic questions we ask in all custody disputes include the following. Are there any custodial orders from other jurisdictions? Where has the child resided for the last 6 months? Has the child been outside the state of Nevada in the last 6 months? If so, why? Who lives with the child? If there are already custody orders, regardless of what state made them, does the child or one of the parents continue to reside in that state? The answers to these questions help us assess if the state of Nevada is the proper place to establish or modify a custodial order. If a child moved to Nevada or moved from Nevada close to a 6-month date, then of particular importance is the exact date of the arrival or move date and any proof that a parent may have regarding that date. Even if a child has not been in the state of Nevada for 6 months, NRS 125A.335 permits the court in the state of Nevada to exercise emergency jurisdiction and to make temporary orders if the child is located in the state of Nevada. There are specific factual elements that must be met for the court to take the action, but it can happen in limited situations. Under the right set of circumstances, those temporary orders can become permanent orders. Under the c.o.g, Nevada judges are encouraged to schedule a teleconference with judges in other jurisdictions when there is a dispute regarding which state has the authority to rule on custodial issues. Regularly, attorneys appear at c.o.g teleconferences and are permitted to argue a parent's position regarding custody.
I'm sorry. When you said that Stewart.Handte was wrong, that Gus was on that signing sheet, you were wrong, weren't you?
I think I told him, and yes, I was wrong, I told him that we did not find the name Stu on this sheet.
Well, but you did find the name Stu, didn't you?
I just now saw that, yes.
Isn't that incredible? 2 years later, or 3 years later at this stage, you finally, for the first time, looked at the signing sheet and you called him a liar initially in the interview?
So I've looked at this sign-in sheet before. I misinterpreted that clearly and thought the name above it was Josie. That is clearly my mistake. I will admit to that, but it certainly was not an intentional overlook.
You mean since August 8th, 2018, this is the first time you became aware of it?
2019, but yes, that is the first time I've interpreted that as Susan.
Well, it's not how to interpret the Susie, is it?
What do you mean?
It says Susie, doesn't it?
It does. Up until this point, I read that as Josie. Each time I looked at it.
And did you misinterpret Stu where it says Stu?
I definitely didn't read it as Stu. Now I can see it as a very sloppy. I can see how it can be interpreted as Stu, and it looks like G-O-S, which I can look at and say is likely Gus, yes.
Likely Gus, and that's their omission too, isn't it?
Yes, it is.
And as we listen to this tape of you specifically told Mr. Handte he did not sign in his certificate.
Yes, I did.
You told him that you had done interviewing and that he was wrong, correct?
Can you repeat that question, the first half of it?
That you had interviewed the people at Stone Valley, and they said that wasn't correct, that he didn't sign it.
Yes, that they had been interviewed, not that I specifically interviewed them.
Oh, you had that information because you imparted it to Mr. Handte, didn't you?
Sorry, I'm having difficulty hearing you.
You told Mr. Handte that when you were interviewing him, and the clip we just listened to, didn't you?
I told Mr. Handte what?
That the two people out there said that he did not sign it.
I didn't tell him that they said he didn't sign the sheet. I believe what I told him was that we did not see his name Stu on the sign-in sheet or Susan.
Actually, we just listened to what you said, and that's not what you said in the tape. What you said in the tape was that you interviewed the people out there independently, both groups, remember, independently. They were there to see someone else. And now we're talking about two independent witnesses. That's what you told Mr. Handte, wasn't it?
Yes, I thought your question was whether or not I told Mr. Handte the witnesses there saw or didn't see him personally signing the log.
Now let's go to that. So what we have done is the initial part of this interview by you, this investigation by you. You have made, as you admit now, crucial errors in your interpretation of what was said. Is that correct?
In what was said, what are you asking me if I misinterpreted?
Misinterpreted when you told Stewart.Handte you didn't put Stu down. You were wrong.
Yes, I was wrong.
Detective Jenkins, when you were filing the affidavits in support of these various criminal complaints, were you putting in there the same erroneous information that you started out with on the first part of August 2019?
Can you be more specific about what information I included in the affidavits that you're asking me about?
Well, the affidavits that you included in there that Mr. Handte that won't survive me by putting
Judge, if I may.
Go ahead.
I believe that most affidavits in support of warrants are sealed. I don't believe in the discovery that I have seen an affidavit in the support of the warrants. So it puts defense counsel in a difficult position in this type of cross-examination to examine a witness who put together an arrest warrant application if we don't have it. I'm not saying with 100% certainty in my thousands of pages that I don't have it. I don't recall seeing it. If it's been supplied to us by the district attorney's office, I don't believe I have it. And of course, my client had a counsel or two before me. But I talked to Ms. Stone. It's her understanding that they don't have the affidavits in support of the warrants either. So I believe, I just think it's a disingenuous objection when an application for a warrant has not been provided by counsel to be in the middle of an examination like this for Mr. Bitar to ask that question and then the state to object when they know that we may not have that document.
And it's been my experience that the sealing of a warrant affidavit is the exception rather than the rule, but Mr. State, I'll allow you to address that.
The disingenuous part of this, and I hate because it's so late in the day to go there, but it's disingenuous to argue, did you make this statement in an affidavit when Mr. Evenson is saying he doesn't have the affidavit? An affidavit, by the way, which does not apply to Mr. Pataro's client. The testimony is Mr. Handte was arrested outright without a warrant. It was only Mr. Hillygus.
What to do, Mr. Handte?
Judge, under the Sixth Amendment, I'm allowed to represent myself.
Well, let's not talk about whether
okay,
hold on. Let's not talk about whether the court should exercise its discretion or make a finding. Is that what you want to do? You want to represent yourself?
Correct, sir.
Yes or no?
Yes.
All right. I'm not taking that up now. How come? I don't have time for this. It wasn't set for this. We're on the eve of trial. I have other things to do. However, I will take this matter up Monday morning at 8:45 a.m. I've already set a hearing on the motion to quash. We'll take this matter up first. And then if you end up representing yourself, we're going to go right into the motion to quash with you being self-represented. If the request is denied, we're going to go right into motion to quash. Mr. Silverberg remains your counsel.
Okay? Do you have a bond to sit on the bench, Judge?
Pardon me?
Do you have a bond to sit on the bench?
So that's enough, Mr. Handte. You can have a seat.
8:45
Monday morning, Mr. Handte.
I understand that, Judge. This court has forced counsel upon me, and it's violation of Rule 1.16 and the Sixth Amendment.
Okay, Mr. Handte, thank you. I understand your position. You're wrong. You're wrong. You're wrong in many different ways. You're also being disrespectful to the court.
I'll sit down.
State of Nevada Executive Department Certificate of Election bears the Great Seal of the State of Nevada. This is to certify that at a general election held in the state of Nevada on the 3rd day of November 2020, Barry Lewis Breslow was duly elected to the office of Judge of the 2nd Judicial District of the state of Nevada, Department 8, for a term of 6 years from and after the 4th day of January 2021. Now, therefore, I, Steve Sisolak, Governor of the state of Nevada, by the authority vested in me by the Constitution and laws thereof, do hereby commission him, the said Barry Lewis Breslow, as a judge of the 2nd Judicial District of the state of Nevada, Department 8, and authorize him to discharge the duties of said office according to law, and to hold and enjoy the same, together with all powers, privileges, and emoluments thereunto appertaining. In testimony thereof, I have hereunto set my hand and caused the Great Seal of the state of Nevada to be affixed on this 30th day of December, 2020. And it is signed with a squiggly line that I suppose is supposed to be Steve Sisolak, Governor of the state of Nevada, and by the Secretary of the
former
state of
governor
Nevada,
now, actually, but yeah.
Yeah, former Governor of the state of Nevada, Steve Sisolak. And it is signed with a squiggly line that I suppose is supposed to be the former governor of the state of Nevada, Steve Sisolak, and by the Secretary of the state of Nevada, Barbara K. Sagosky. I, Barry Breslow, do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and the Constitution and government of the state of Nevada against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same, any ordinance, resolution, or law of any state notwithstanding, and that I will well and faithfully perform all the duties of the office of Judge of the Second Judicial District of the state of Nevada, Department 8, on which I am about to enter. So help me God. Barry Breslow. Subscribed and sworn to before me this 4th day of January AD 2021. And there's an illegible signature, which it's difficult to make out exactly who that would be, but it's not the Chief Justice of the Supreme Court that I guess ordinarily signs these documents, because that's scribbled out and it says Chief Judge, Second Judicial Court.